Hello and welcome to the world of NDE 4.0. My name is Vrana. And today is a great day because today we will finally talk about the EU Data Act. Now, in this video, we will discuss the basics, what's written in this law, and then we will discuss what this act means to both a B2C, a business to customer environment. So for all the smart home enthusiasts, for all the people who want to use health trackers and so on, and also for a B2B environment. So for kind of all industries in general, but for sure also for those who want to do, let's say, a smart factory, digitization, digitalization, digital transformation, Industry 4.0 or NDE 4.0. Now, before I get started, I have to ask you for a small favor. I guess you all know that YouTube uses AI to evaluate a channel. And actually, I have done a couple of videos on AI, and I will leave a link to those videos right here. And that evaluation that YouTube does on those videos, that depends on the user interaction. The more interaction, the higher the rating of a video. Therefore, please subscribe to this channel, click on that little bell, give it a thumbs up, and the two most important ones, write a lot of comments. For example, what do you think of the Data Act, and what do you think how it implies to your business? And the second important one is, please watch the videos all the way to the end, because this is how you can support the YouTube channels that you really like. Okay. Now let's get started. But as this is an act, as this is legal information, I have to tell you I'm not a lawyer and I cannot give any legal advice. This video is my opinion and is intended as information. If you think that this is important for you, for your business, then please get in contact with somebody who knows the EU Data Act or the EU Data Strategy and seek official legal counsel. Now, where does the EU Data Act come from? And this actually started with these guys, with John Deere. John Deere, a couple of years ago, they built more and more computers into their tractors and farm machines. And they started with building in computers, and then they started to lock farmers from accessing the data which was recorded by their own machines. Not only that, they got to a point that they made them go to official John Deere repair and maintenance shops. And if you think back to the history, what did all the farmers do? They repaired their own machines. And now they couldn't do it anymore. They couldn't even go to independent repair and maintenance shops. They had to go to John Deere. John Deere considered themselves as the sole owner of all the data collected by the farmers' machines. And they argued, oh yes, we have created that software. Our software collects the data. We belong to copyright of that software. So all of that data should belong to John Deere. They even went one step further. They said, okay, even that you paid a lot of money for your tractor, you don't own your tractor. You only have a license to operate your own tractor. So, to cut it short, this was an attempt of John Deere to monopolize the growing market of digital services. They even started to cooperate with large agricultural companies like BASF, Monsanto, and you name them, to sell them the data collected with the farmers' tractors. And that kept a lot of courts all around our planet quite busy. And it led to the EU saying, okay, there is this growing market of digital services. And currently, the hardware manufacturers are trying to monopolize this. And with that, limiting innovation. And so their idea was to go from this current situation where you have a manufacturer who sells a product to the user, then the user has that product, let's say this small device, and then the user has to go back to the manufacturer to actually also get a service, a software service from the same manufacturer. He couldn't go to somebody independent. And so the EU Data Act now goes one step further and says, okay, we want to split those markets. We want to split. One part is the market for the connected products. You buy the connected product from somebody. But on the other side, there should also be a market for data-driven services to actually drive innovation, to create a new market, which would be good for all of us, because new market means better business for all of us. So the idea is that the data shouldn't go back to the manufacturer. It should go directly to the user, and then the user can give it to every data service provider he wants to. That data service provider, it can be the same one as the manufacturer, and actually the manufacturer has a big benefit because he knows the connected product better than anybody else. He can most likely do a pretty good job at providing a data service to you. But if he can't, yeah, then you can go to somebody else. Now, this law is not just, it's one out of many. There is actually what is called the European Data Strategy, which kind of started with the GDPR, which we all know. And officially, GDPR is not part of the European Data Strategy because it was started before actually this data strategy was started, but I would think still it belongs to it. And you can see there is a whole list of acts which have been created. And the EU Data Act is the one which, or one of the ones which was created in 2024. The AI Act is another one. But we don't want to talk about AI Act or all the other ones. Now, the EU Data Act, it was entered into force already in January of this year, in January 2024. And it will be applicable until starting September 12, 2025. So if you're a hardware manufacturer, you still have kind of about a year. But then you have to comply with the EU Data Act. And the EU Data Act, it is applicable both to B2B and B2C products. And it is valid. And you might be saying, why do I care? I have a business in the United States or in India. Why should I care about the EU Data Act? If you want to sell, rent, or lease your product somewhere in the EU, you have to comply with the EU Data Act, starting September 12, 2025. So let's have a look what's in the EU Data Act. Now, the Data Act, it really has three big things they regulate. Number one, the access and use of data for users and third parties. What we have already kind of discussed in the beginning, but we will get more into the details in a little bit. Number two, it talks about fair rules for data usage contracts. If you think about that contract which John Deere gave its customer, restricting them to, oh, you are not the owner of your own tractor anymore. You only have a license that you can use it. Is that a fair contract, or is that using your monopoly? And number three, and we all know the story. Currently, if you are with one cloud service provider, you want to switch to somebody else, then your nightmare starts. So therefore, this is the third part is really about simplifying to switching from one cloud service provider to another one. So in the following, I will first go into some important details of the law. It will be a little bit dry, but try to follow me. And then I will discuss what the law means to the various groups, to the various stakeholders we have in the ecosystems. And for sure, I will add some chapters to this video so that you can quickly jump to the part which is of most interest to you. But now let's get started with some information where you can find some more information. And this is one article I wrote for materials evaluation, which is actually also available on LinkedIn, and you can find a link right here. And the second one, the upcoming second edition of the NDE 4.0 handbook, will also have an article on cybersecurity and data ownership, and you can already access the preprint of that chapter right here. So what does the EU Data Act stipulate? And we already talked about it is about connected products. So what means a connected product? Connected product means an item that obtains, generates, or collects data concerning its use or environment, and that is able to communicate product data via an electronic communication service, physical connection, or an on-device access, and whose primary function is not the storing, processing, or transmission of data on behalf of any party other than the user. Well, let's have a look into what this really means, or what my opinion is what it really means. So, a product which obtains, generates, or collects data concerning its use or environment. So this little device, which is a heart rate, I don't know how it's called, it collects data from its environment because I can put my finger in it and then it collects data from its environment. It also collects data concerning its use. The same is true, for example, for an NDE instrument, for a UT instrument. With the UT instrument, I'm scanning my part, I am collecting data from that component, from its environment. So number one, kind of all the NDE devices we have, we can put a check mark. All of them belong to this category of connected product. There's a second clause. Via an electronic communication service, physical connection, or on-device access. So, if that device has a Wi-Fi connection, a Bluetooth connection, or whatever, some connection, then it is a connected product. But also, if it doesn't have one of them, but it has a connection to, let's say, you can put an SD card into it, or you have a USB port on it. And even if that's hidden within the device, as long as the manufacturer has some sort of an access to the data, then you also have to give that connection to your customer. And now the last one, and whose primary function is not the storing and so on. Those are servers. So servers are not included in the EU Data Act, which also makes sense. Because on the server, you store all kinds of data from somebody else. Summarizing, kind of all of those little devices we have, which have some kind of a connection, they are all part of the connected product range. So now what's a related service? Related service means a digital service other than an electronic communication service, including software, which is connected with the product at the time of the purchase, rent, or lease in such a way that its absence will prevent the connected product from performing one or more of its functions, or which is subsequently connected to the product by the manufacturer or a third party to add, to update, or adapt the functions of the connected product. Cut it short. If you have a device and there is a software or an app or a web service or however you want to call it, which is kind of somehow connected to this instrument, then that's a related service. And the EU Data Act is both for connected products and related services. Now, one small but. product data. What is product data? Now, product data means data generated by the use of the connected product that the manufacturer designed to be retrievable via an electronic communication service, physical connection, or on-device, blah, 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 blah. So, if you create a device like this calculator, who does not have any electronic communication service, any physical connection, or any on-device access, then, but only then, you're out of the EU Data Act. And you do not have to give the data to the customer. With this device, it could actually be quite tricky, because what you can see here on the bottom is it has a small connector. This is so that you can connect two of those devices with each other, and so that you can copy one program from one of those calculators, which are kind of intelligent devices, to another one. I would think that this one even falls within the connected product because it has an electronic communication service. So you have to see this borderline here. There's only if you design your product really in a way, and this is, for example, for some handheld devices, which do not have any USB stick, any SD card, any whatever, then only then you're out of the EU data. So we clarified a little bit of what we're talking about. Now let's have a look into what are your obligations, what are your rights you're gaining with the EU Data Act. And now we are getting into Article 3, number 1, direct access. Connected product shall be designed and manufactured, and related services shall be designed and provided in such a manner the product data and related service data, including the relevant metadata necessary to interpret and use those data, are by default easily, securely, free of charge in a comprehensive structure commonly used in machine-readable format, and were relevant, technically feasible, directly accessible to the user. And this is where it's really getting interesting. If you still have an instrument which stores data in a proprietary data format, you are not fulfilling the EU Data Act. Look at all those adjectives describing how you have to store that data. You better start now to work on something like that. And I would think this, what they write here, is quite a high standard, especially the machine-readable format. If you want to know a little bit more in detail what they are talking about with machine-readable format, I have actually done a video on semantic interoperability or ontologies in the past, and I will put a link to that video right here. Now, this one has one small but in it. Very relevant and technically feasible. So there could be devices where they cannot really give you, or where a manufacturer cannot really give you direct access. In that case, they have to give you indirect access. Where data cannot be directly accessed by the user from the connected product or related service, data holders shall make readily available data as well as the relevant metadata necessary, accessible to the user without undue delay of the same quality as is available to the data holder, easily, securely, free of charge in a comprehensive structure commonly used in machine-readable format, and were relevant and technically feasible continuously and in real time. This shall be done on the basis of a simple request through electronic means where technically feasible. So, if you have a device where direct access is not possible, then you have to give your customers indirect access. This could be through some app or web portal or whatever. But again, the data format needs to be open, free of charge, comprehensive, structured, and so on. And continuously and real time. I think that also lays a quite high burden on the OEMs, what they have to do. And one more, it cannot be some complicated thing where you lose your mind registering for it. No, it has to be on basis of a simple request through electronic means. So, we discussed already about the direct access, where the data goes to you, and then you can give it to whatever data service provider, and that could be the manufacturer, to get additional services. Or you can also do it, the data processing yourself if you want to. If that's not possible, then the manufacturer has to give you indirect access. So the data goes nevertheless to the manufacturer, but then the manufacturer has to give the data to you so that you can then give it to a data service provider. And by the way, with the data the manufacturer got from you, if he wants to use the data for his own purposes, then he has to ask you, because it's your data. Now, I think that's already a lot, but there is more in the Data Act. And that is, you want to use a third-party data service provider. Then the law says, okay, dear manufacturers, please give the data to the data service provider directly. Let's have a look a little bit into what the EU Data Act says about this one written form. Upon request by a user or by a party acting on behalf of a user, the data holder, so the manufacturer of that device, shall make readily available data, as well as the relevant metadata necessary to interpret and use the data, to a third party without undue delay, of the same quality as is available to the data holder. So if the manufacturer has a certain kind of data, then you can request from him that he gives the data in the same quality he has the data himself, that he has to give that data to a third party. And for sure, again, same quality, easily, securely, free of charge, in comprehensive structure, commonly used, machine-readable format, and where relevant and technically feasible, continuously and in real time. Now again, there is a small but to the whole story, and that is only valid for B2B relationships. Where in B2B relations, a data holder is obliged to make the data available to a data recipient, it shall agree with the data recipient that arrangements for making the data available shall do so under fair, reasonable, and non-discriminatory terms and conditions and in a transparent manner. So, you can take a little bit of money for making that data available to a third party. So if you are a manufacturer, your customer is a B2B customer, and he tells you, oh, please give the data to a third party, then yes, you can get some money for it. But the money you can get is more or less only for making that data available, for the effort you have. You cannot put on top of it a big profit, but you can get some money for the services you have to offer. Now there is another small but to this whole article number 5. And that's in number 3. Any undertaking designated as a gatekeeper shall not be eligible third party under this article. And so now you might be asking, oh, what's a gatekeeper? Okay, now we have to look into one other law, one other act of the EU, this called Digital Markets Act, which defines certain rules for so-called gatekeepers. Those gatekeepers are the large companies like Alphabet, Google, Amazon, Apple, Booking, ByteDance, meaning TikTok, Meta, meaning Facebook and Instagram, Microsoft. So you see the really big ones. Those really big ones, they cannot be a third party because the EU doesn't want one of them to becoming the one which is offering all the third party services to all industry and to all private people. They want a market, they want competition, they want innovation. Now those big players, they can still provide the service or the architecture behind it. They can still provide the server farms, but they cannot run the service on top of the server farm. That has to be a smaller player who provides then the services you need on basis on those platforms. So now, this was point number 1. But let me assure you, for point number 2 and 3, what the EU Data Act regulates, it's a lot shorter. I'm not going into that many details. But we also have to talk a little bit about fair rules for data usage contracts. And the EU Data Act stipulates what is unfair, or it stipulates what rules are there for contractual terms. A contractual term concerning access to and the use of data or liability and remedies for the breach or the termination of data-related obligations, which has been unilaterally imposed on an enterprise or another enterprise by an enterprise on another enterprise, shall not be binding on the later enterprise if it is unfair. For me, that should have been always the case. If a contract is unfair, it should never have been done. And they are also stipulating what means unfair. A contractual term is unfair if it's of such nature that its use grossly deviates from good commercial practice in data access and use, contrary to good faith and fair dealing. Unfortunately, we find some corporations using such contractual terms. And if we think back on the story from John Deere in the beginning, that were unfair contractual terms. And this is why, unfortunately, we need such acts and such laws. But we have to limit some corporations going out of or using their monopoly structures. Okay, number 3, cloud service providers, in particular regarding the simplification of switching between providers. So they want to make it easier for us. They want to make it easier for terminating a contract, for concluding new contract with a different provider, for porting the customer's data and digital assets from one to another, for achieving functional equivalence in the use of a new data processing service, unbundling data process services from other data processing services. So for me, it is also a pretty important part of the Act. But we will not go into the details. So if you're interested and if this really is something your business needs to take care of, please go further into this topic and take some legal advice. So we talked about those 4, but in my series of point number 4 in the Data Act, which is important, and that is the definition of data holder. Because up to the moment, no law stipulates who owns data, except for some artistic data and personal data. But for all the other data ownership is not clarified. Not in any legal system I've heard about. And the EU Data Act is for the first time, it doesn't stipulate data owner, but it stipulates data holder. And data holder, according to the EU Data Act, means a natural legal person, means a natural or legal person that has the right or obligation, in accordance with this regulation, applicable union law or national legislation adopted in accordance with the union law, to use and make available data, including where contractually agreed product data or related service which is retrieved or generated during the provision of the related service. So for the first time, they are kind of stipulating data ownership. And I think this is an important first step. It's just the first step. I think we need clarification who owns data. Because everybody thinks that the person who created the data owns also the data. But that's not true. Technical data, kind of everybody owns it and nobody owns it. And I will be doing a video on this topic in the future because I think it's so important for all of us to better understand the topic data ownership. But that's not for this video. Now, let's discuss a little bit the implications for the different groups we have. So, if we talk about B2C, all of us private persons, the smart enthusiasts, the health tracking guys, we will all benefit because finally we can attach the device we bought to our smart home. Or we can attach the health tracker we have to our smart home. It's not anymore just that the Chinese guys or whoever created it are then collecting a lot of data from us. No, we can use that data to track our own health, to combine it with other data, to learn more about our health, and perhaps finally to have a better and longer life. Also, if we talk about B2B, everybody who wants to go towards a smart factory, digital transformation, digitalization, NDE 4.0, to increase a little bit the automation within your factory, to save money, to compensate for the personnel shortage we currently have, then it will be a benefit for you. And also, if we think about the third-party service providers, it's a new market. There will be dozens of third-party providers out there which will have a good business in the future, which will be able to hire employees to provide the services to you which you really need. So the data creators, the users, all of them will clearly benefit. All of us who want to drive innovation will clearly benefit. The story is a little bit different if I think about equipment OEMs. A lot of them were using proprietary interfaces and data formats and encapsulating their device for customer retention. But this was clearly limiting innovation. Now they have to think about new business models. They have to become more innovative, which isn't actually good for all of us. Because innovative companies will stay in the market. So all in all, it will be good for the market. And we have to start now because the Data Act, it is becoming reality. It is already a law and it will be in place in September 2025. So now to all the OEMs, you have to think about, okay, how do I implement interfaces and data formats so that my customers can get the data in a way which is legally stipulated in the Data Act. And perhaps one thing I should be mentioning, there will be ways for those who don't want to do it to make them pay. I think they are still in works. But we already saw it with the GDPR. Those who didn't fulfill the requirements of GDPR, that it is quite costly for them. Thank you for watching. What do you think of the Data Act? What do you think about my conclusions, my thoughts? As usual, you will find more information in the video description. I hope you like this video. I hope you subscribe to this channel. I hope you click on that like this video. I hope I will see you soon. So thanks for watching. See you soon. Thank you and bye.